morning. Good morning. Good to see everybody here bright and early this morning. I'm going to give a case update. So I know a lot of you are involved in defect matters. A lot of you are doing expert reports. I wanted to just give you an update on two really interesting matters that we've had in the last few months that have come out of the tribunal. Full disclosure, it was Mr. Ovidi's reports who have gotten us through on this one. So the success of these cases from our perspective was largely due to Joseph's expert report. So Joseph, well done, and feel free to add anything that you think I might have missed. So the cases primarily deal with the consequences of breaching statutory warranties, and I'll take you through the warranties just as a refresher in a moment. So we'll talk about the consequences for a builder of breaching the statutory warranties, when a money order is made against a builder, and then we'll finish up with some lessons for both the homeowners and builders involved. The statutory warranties under the Home Building Act. These are set out in 18B. There's a whole bunch of them, but it includes work will be done with due care and skill. That's the biggie. That's the one often that a builder will fall short on. That the material supplied will be good and suitable for the purpose. Works will be done in accordance with any law. So that includes the NCC, the Australian standards, the development consent. Work will be done with due diligence. They'll hurry up about it. They won't take their time. And that it's going to result in a dwelling that's fit for occupation as a dwelling. Now, the statutory warranties are imported into every single residential building contract. They can't contract out of them. Even if a contract does not refer to the statutory warranties, they are still deemed to be included in that contract as if they had been set out there in full. It doesn't matter that they had not been included, they're still imported into that contract. Now, if a builder breaches the statutory warranty, they're facing significant liability, and we'll take you through an example of that in these two cases. When we take a matter to NCAT against a builder, NCAT, assuming there are defects and assuming there's a breach of the warranties, NCAT's got two choices. One is to make a work order. The builder returns to rectify, or a money order. And that is where the builder is required to effectively pay for the cost of rectification. And when a homeowner is seeking a money order, it's necessary that we go to the tribunal with evidence not only of the defects, but also of evidence of how much it's going to cost a remedial builder to come in there and rectify. So often it is the case that a homeowner will come to us and say, we don't want the builder back on site. I don't like them, I don't trust them, they're shoddy, they're dodgy. We don't want them near our family. The tricky part of that is that the tribunal will always prefer to make a work order because the cost to get a remedial builder in to rectify is always more expensive. So the first preference for a tribunal is to get the builder back to rectify. That's called the preferred outcome. And it's a bit of an uphill battle for a homeowner to get a money order. So in that backdrop, I'll take you through these next two cases. Case one, homeowner comes, has a contract with a builder, it's worth $500,500. He came to us, he had commenced proceedings for defective and incomplete work. Now, we had to get extensive expert evidence. Joseph was one of those. The evidence showed that there was issues with the structural slab and footing issues. It also showed that there were 72 missing piers. I would not forget, ever, the time that Joseph called me and said, hey Sharon, I think this is a knockdown. My first one. I've been practicing for 25 years. So originally the client had come to me, it was a very simple defect and incomplete works case. Fairly run-of-the-mill. We unfortunately do them fairly regularly. I've never ever had an expert ring and say, hey, this is a knockdown. This is a brand new house. No OC had been issued yet because of the incomplete works. Client hadn't moved in yet. It is a brand new house that seemingly looked okay, save for some defects and incomplete works. The tribunal found there were major defects. It accepted in its entirety our expert evidence. And that evidence went to the defects themselves and also Joseph's quantification evidence. There had been a breach of 18B, the statutory warranties. The works, funnily enough, had not been in accordance with the plans, which you might imagine included piers. The defects were so severe, the tribunal agreed that demolition of this brand new house was required. So the question then was, should we get a money order or a work order? The tribunal considered that the works had been left incomplete. There was a failure to comply with the rectification order. So before I had gotten involved, the Building Commission had gone on site and said that there was a rectification order. At that point, it hadn't appreciated there were no piers. We had to get some geotech evidence to prove that. The tribunal considered that the builder's licence had already been cancelled before our proceedings had been commenced. They had gotten some expert evidence, but when we started talking about geotech evidence and structurals and, hey, did you put some piers down? Funnily enough, they didn't engage with that. So the outcome with that one was that we got a money order for $500,000 in costs. Now, John and I were just having a discussion a moment ago about the unsatisfactory state of the HBCF scheme at the moment. Now, the reason we stayed in NCAT for this matter, so our quantification evidence did indicate that the costs of this matter were more than $500,000. That is the jurisdictional limit in NCAT, $500,000. The client decided to stay in NCAT, not because, excuse me, they only wanted $500,000, but because we didn't think the builder was good for anything more than $500,000. So we could have gone to the district court, we could have gotten an order for the $700,000, $800,000 that we thought this matter was worth. Remember, the whole contract was only worth $500,000. But to knock it down and to start again, it was going to be more than that original contract price. There was no point in going to the district court in circumstances where even if we got an order for $800,000, the builder is not good for it. So the plan here was to get our judgment, the maximum of $500,000, and get it quicker because we were already in NCAT. It was quicker to just proceed with the NCAT matter. But if this builder goes into liquidation, the client can then make a claim on the HBCF. Some of you would know that the maximum we can get under the HBCF is $340,000. So regardless of whether I have a judgment for $800,000, $1 million, or $500,000, the client's really only going to get $340,000. So big win legally for us. Unfortunately, the client is still trying to get his money. He hasn't paid yet. The judgment is due. We are taking steps though to make a claim on the HBCF. The trigger on the insurance is the builder dies, disappears, or go insolvent. The other one that is a little less well known is that he fails to pay a money order. Your money order though. So he had failed to pay a previous money order of the tribunal in a case that was before ours. We couldn't trigger the insurance yet because it has to be a failure to pay your money order. That is the step we're taking at the moment. He's failed to pay our money order within the time specified. We're hoping to get a payout for him of $340,000 so the client can go on and sort out what he wants to do with this property. So a win in terms of we did get the maximum jurisdictional limit for him. The builder is not coming back to try and rectify this house and retrofit some piers, but still not necessarily a win for the client because he isn't going to get his full $500,000.
Sharon, is this on the website?
It's not. It's not a published judgment.
It's not?
No. But I can speak to you about it after.
Very good, thank you.
Yeah.
Sharon, can I just ask, what was the circumstances of his licence being cancelled? Was that before
it was before mine. He hadn't complied with a work order.
Of a previous one?
Yeah, yeah. He was a frequent flyer of the tribunal.
Is there any action against the certifier who certified the slab?
No, No, not at the moment. So case 2. This home was purchased after renovations had been done by an owner-builder. So the renovations had been conducted under an owner-builder permit by the vendor. Our client moves in and pretty much immediately finds out that there are some serious defects, including failed waterproofing, non-compliant footings, subsidence cracking and structural damage. Now, it wasn't the entire house that had been built by the owner-builder, it was just the renovation component. The matter confirmed that the owner-builder does not need to have a contractor licence by reason of the owner-builder permit. Section 18C of the Home Building Act says that the owner-builder is still liable to subsequent owners, and there's a deemed contract for the statutory warranties between the owner-builder and the subsequent owner. So those 18B warranties that we were talking about earlier that are imported into every contract, those warranties also flow through in circumstances where it's an owner-builder, not just a builder. The owner-builder is responsible for the work of any trades that they engage. So just because it's an owner-builder, it doesn't change the situation with the statutory warranties. In this one, the tribunal found that there are major defects and consequential damage. So the work that had been done for the renovation then resulted in consequential damage for the balance of the house. Excuse me. Again, tribunal accepted all of Joseph's evidence in terms of, thank you so much, in terms of both the defects that were present and the quantum, and also of our structural engineer, finding in particular that there had been breach of the requirement to do the work with due care and skill. Again, work or money order. So our client again had said, we do not want him back to rectify. I don't trust him. This particular builder did not speak English as his first language. There were some language barriers. It was a difficult relationship for him to be able to rely on this gentleman to come back and rectify. The builder had denied the seriousness of the defects and the scope of rectification. He was trying to say, it's not that bad, I can just do X, Y, Z, which was far less than the scope than Joseph had recommended. The tribunal noted that the builder lacked the qualification and the necessary licensing. The builder was also insisting on, if someone else was going to come in and do the work, that he would supervise. The tribunal had concerns about that because the builder wasn't accepting that the seriousness of the defects, wasn't accepting the scope, wasn't accepting that he needed a licence. There were severe concerns held by the tribunal. There was, again, a breakdown in the relationship and trust between the builder and the homeowner, and the tribunal wasn't satisfied that there would be a work order would result in it being cost effective, and thought it would likely lead to renewal proceedings. So for those who don't know, renewal proceedings are where a work order is made by the tribunal, the work order is not complied with by the builder, and the homeowner can then commence proceedings again to say the builder has not complied with the work order. In those circumstances, we need evidence to show which elements of the work order have not been complied with. We can't add new defects. We can only go off the work order that has not been complied with. And the tribunal was concerned that a work order in this instance would mean renewal proceedings being commenced, which was a waste of the tribunal's time. So in that one, we got a money order again, $148,000, which was the full amount of rectification set out in Joseph's report. We also got costs for money for alternative accommodation during the demolition and the rebuild. Costs in that matter are still, we're still waiting on whether or not we're going to get costs. I'd be very surprised if we don't. And in that one, we are getting paid. So we negotiated an outcome with the builder to pay by instalments, and so far he's keeping up to date and he's paid more than half. So the client is happy with that. So just in terms of the general approach by the tribunal for work orders and money orders, and a lot of you will see the clients before we do, before they come to us. So in terms of their expectations and managing those expectations, I think this is just good information for you to have in terms of what does the tribunal think about when determining whether or not to make a work order or a money order. So as I said, the preferred outcome of the tribunal is that the builder will return to rectify. This is set out in section 48MA of the Home Building Act, which says that a court or tribunal in determining a building claim where there's alleged defects is to have regards to the principle that the rectification of the work be done by the builder. And that is the preferred outcome that I was talking about earlier. Now, there is a lot of rationale for work orders. It's quicker, it's cheaper, it's more efficient. We all know remedial builders are far more expensive, and they could do the work. A builder can do the work far cheaper than a remedial builder. This will often mean getting their own subcontractors back who did the work. They may be doing it under warranties. It's far more expensive for someone to come in and try and figure out what needs doing and fix it up over the top of the original builder. So that is the rationale for a work order, but in certain circumstances, a money order will be made when the rectification by the builder is inappropriate. So similar to the cases that I've just gone through, the factors that might be considered will be the seriousness and extent of the defects, and also whether the builder accepts the seriousness and extent of the defects, or whether they continue to deny it. The scope and feasibility of rectification, the relationship and trust between the parties, whether the builder is licensed and can get insurance, and the likelihood of a timely and cost-effective resolution. Now, when a client or a homeowner is going for a money order, it will be necessary to have evidence on all of these issues as far as they can in terms of their affidavit versus expert evidence. So in particular, for example, you might have evidence on with respect to efforts by the builder to come back and rectify, and those efforts have not been satisfactory. Any relationship breakdown, why has it broken down, any details as to why there's this lack of trust and breakdown between the parties. So in terms of lessons for builders, they need to be careful to not lose their opportunity to return and rectify. They need to know that they will be exposed to remedial costs, which is going to be far higher than what they could have done the work for themselves. They need to know that there will be potential licensing and compliance consequences. For example, if they don't comply with a work order, they need to ensure that they are engaging with the process and get their own expert evidence. And if they do have expert evidence, they can't then put forward a position which is contradictory to their own expert evidence. So in one of those matters, he had expert evidence, but then proceeded to stand in the tribunal and say, but I know best. I've been practicing, I've been building, this guy's only been an engineer for 10 years, I've been building for 40 or 50, therefore I know best and we don't need to look at that scope. There's going to be a real problem with that in circumstances where we then have three potential scopes. The tribunal is not necessarily going to choose that builder's Band-Aid scope. So early realistic engagement is essential. The builder really does need to engage with the process and put forward realistic solutions if they are going to be allowed to return to rectify. In terms of lesson for the homeowners, I think these cases really give them reassurance. Notwithstanding the preferred outcome, it's important for them to know that in certain circumstances they will get their money order and the builder will not be allowed to return to rectify. That money order will then enable the homeowner to go off, get a remedial builder and get their property rectified. The risk in a money order though is that sometimes it might be worse than they anticipate. So they may be given $150,000 to rectify, but actually it's going to be more expensive, or because it's worse than they had anticipated, or because building costs have increased. So we might get that expert evidence 6-12 months before the order is made. By the time the order is made, they get paid, the remedial builder comes in to rectify, building costs have gone up in the way that we know that they have been lately, and that money order is actually not sufficient. So there are also risks in getting a money order for a homeowner. Notwithstanding that, often that is what they want, so that the builder does not come back and rectify. So the key takeaways, these statutory warranties can't be ignored. They do have real financial consequences. A builder can't just assume they are going to be allowed to return to rectify. They do need to prove that they're capable, they're licensed, they can be insured, and that they're willing to prepare the scope that is ordered by the tribunal. The cases show that the tribunal is willing to award a substantial compensation in the term of money order. It won't always be a rectification order, and they can't be assumed just because of the preferred outcome. And it's important early to start documenting each party's position. So every time the builder has offered to go back to rectify or has rectified successfully, or on the flip side, each time a builder has said they're going to come back, hasn't shown up, or has come back and the works have not been satisfactorily rectified. Any questions?
Is there a reason why that first matter wasn't published?
No. I don't know why the tribunal decides to publish some and not others. Neither of those two judgments, interestingly, were published. I don't know the rule, but we checked just this week, and they're not on the website. So we're also preparing an article in relation to the two matters, which I can share with you if you want to just reach out and get in touch. We can send you an email. But for some reason, some are published and some aren't, and I'm not sure the reason why.
And in that matter, did the tribunal take into consideration the final payment of the contract, and if it was made or not?
No.
Didn't come into account?
It was made. There was a very small amount left outstanding. I think there were some council fees. He did try to say, look, I haven't finished the works because there was some money outstanding. In fact, he actually at some point had issued a notice of intention to terminate because there was this small amount of unpaid. None of it in the end was relevant because of this major peering issue, because he couldn't say, look, if you make payment, I'll go back and rectify, or I'll go back and I'll complete the works, in circumstances where he missed 70 peers.
One more, if I can.
Yeah, sure.
If you went to HSBC, would there be some sort of jurisdiction in unjust enrichment if you got your settlement and then tried to claim against the policy as well?
You can't double dip. So if he was to be paid out, then the policy isn't triggered, because it's only triggered for failure to pay a money order.
Mm-hmm.
So the most common triggers are die, disappear, or go insolvent, or fail to pay the money order. In circumstances where he has paid the money order, that doesn't trigger the policy, so they won't pay out. But no, if a double dip was allowed, we'd be all for it.
With the first matter, after receiving the money order, can the homeowner decide to keep the house as it is or then knock it down? If they go with a rectification cheaper option?
Look, it does happen. It does happen. They get the money, they don't do anything to rectify. The difficulty there will be in any disclosure requirement for in a conveyance. Certain questions might be asked. There may be issues in terms of his failure to disclose. But
well, I mean that if they get an engineer and then put alternative solution like underpinning and fix the issue, keep the house as is.
yeah, there was a lot of and Joseph, look, you may want to step in here, but there was a lot of discussion about whether or not this could be retrospectively, I mean, piers can't be retrospectively fitted, but there was discussion about what is an alternative solution. The evidence in the end, we had asked our experts to say, look, we may not get a knockdown. This is a really big deal. It's a brand new house. It's drastic. Can you please prepare us an alternative solution in circumstances where the tribunal is not prepared to order a knockdown? And the practice note now has been amended for experts, the Code of Conduct has been amended to require experts to provide alternative solutions. So what we did is went with option A. This is our preferred solution and this is how much it's going to cost. Or in the alternative option B, and this is how much it's going to cost. In the end, the tribunal went with option A and agreed with us and awarded the maximum amount. It's a matter for the owner as to whether or not they want to go with option B, particularly in circumstances where they've not been paid the full amount for option A.
I think with the owner on this one, my discussions with him were that he would rectify and move on with it rather than demolish it.
Yep.
So he'd fix it, essentially.
So legally, there's no force to the homeowner to follow the same method.
In circumstances where there is a viable option B, then it's a matter for him as to whether he goes for option A or B, but there is no requirement. Once he gets paid out, there's no requirement that he then carries out with that. And look, we know I was paid out recently for damage to my carpet because of water ingress, and I haven't fixed my carpet. So it's it happens often that an insurance claim is made, paid, and never fixed because the homeowner can live with carpet that once got wet and now is dry. Okay, David, over to you. Yep.
One question, please. In the situation where both experts agree at the conclave on most defects
Yep.
against the builder, and I see this all the time, you kind of walk into the hearing as a builder knowing the outcome.
Correct.
The experts have agreed on everything. That's then usually a good opportunity for the builder to make an offer
Mhm.
to the owner,
Yes.
since he's got both experts' evidence.
Correct.
They've agreed on most things, and I advise this to many of my builders: like, you've got your evidence in front of you. This is
Yes.
what the tribunal's
It's only
been
going
saying.
one way.
Time to make an offer.
Yeah.
Because you know your outcome. Does that then, if say the builder makes an offer to fix it as per the expert's advice, and the owner rejects it and says,
Yep.
I'm going to hearing, stuff, yeah. Does that put the builder then in a situation to claim costs against the owner if the outcome ends up being the same
Yeah.
as the offer he made?
Yes. So in that circumstance, and John and I have got something very similar where as a homeowner, they have an expert report, builder ultimately agrees. The tribunal will be guided by that expert report. The question often then is work order or money order. So if the builder has offered to perform the scope as per the joint report, it's going to be difficult for a homeowner to then get a better position than that. It might be that the homeowner can argue for a money order. So it might be that the builder's offer is, I'll perform the scope of works as per the joint report, but the owner is saying, well, I want a money order as per the scope, the cost of the scope of the joint report. So that may be where the parties are different. That may be, it's literally just work order or money order. In circumstances where there are costs, the tribunal is a non-cost jurisdiction unless certain circumstances arise in that the parties have been unreasonable. The exception to that, is where the claim is worth more than $30,000. If you're over $30,000, you're in the cost jurisdiction. So costs will often follow the event. If an order is made, if the builder has offered to rectify as per the joint scope, and that is the order that is made by the tribunal, then there is good argument for the builder to say, I offered that, we shouldn't be here, we shouldn't have spent the cost of the hearing, I shouldn't have to pay costs, and in fact, my own costs should be paid. And that application will be made at the end of the hearing, often on the papers by submissions, and if any cost, the order in that instance might be that the builder pay the owner's costs up until the date of the offer, but from the date of the offer onward, the owner needs to pay the builder's costs, because had they accepted that offer, we wouldn't have the cost of the hearing. But it's very discretionary by the tribunal. There are sometimes, in that $500,000 case, I did ask for indemnity costs in that matter from a particular date in the proceedings. The tribunal said, no, I'm just going to give you ordinary costs for the whole way through, but I had hoped for, not that it would have mattered because we're not going to get it anyway, but I had asked for indemnity costs from a particular point in the proceedings and I didn't get it. So it's all discretionary and theoretically that's what should happen, but often it doesn't.
Where do you sit on experts providing advice to accept offers?
There's nothing saying that they can't. I would recommend experts don't give legal advice, but if
is recommendation to accept an offer legal advice?
I don't know that an expert is qualified to talk about the ins and outs and call to bank offers and that kind of thing. Certainly an expert could say, look, if you go to hearing, I don't know that you're going to get any better because I agree with my counterpart. So more than likely, the tribunal is going to make an order pursuant to a joint expert report, particularly if everything is agreed. It's certainly helpful when I've got an expert who helps me manage the client's expectations in terms of, look, I don't think you're going to get any better, or I've agreed to their scope, there's nothing that we're fighting about now. But as I said, I would caution an expert from giving advice in relation to offers, call to banks, the likelihood of indemnity costs and that kind of thing. Thank you.
Thanks, Sharon. Thanks, Sharon. I might just say that we need to stick in our lanes, and the lawyers are good at negotiating that sort of stuff, and we need to hold ourselves back and stick to what we do. Okay, I'll now pass the time to David. Thank you, David.
It is. Thank you, John. Thank you, Sharon. Very much a tag team. That's what we do at Bartiers. It's all about collaboration and a team. And also when we're working with experts, it's all about the team. Just to emphasise something Sharon said, which is that phrase client management, managing client expectations, very, very important. It'll be smoother for everyone if from day one those clients' expectations are managed. So please bear that in mind. Now, so I have been the beneficiary of a nice little segue from John. At the outset, he talked about provisional membership of the society, where someone comes in, is already working with a member, and might be go and do the site inspections or something as part of the preliminaries for an expert report. So what I'm talking about is co-authored reports. Can more than two people be involved in preparing an expert report, which is then sought to be tendered as admissible in proceedings, whether they're in NCAT or in a court. So can the ultimate author, can you rely on other reports, whether it's internal or external? Do you have to disclose that you're not the sole person who has contributed to the report? And if so, what do you need to disclose? So we all know about the expert report or the expert witness codes of conduct. There's different ones for courts as opposed to the tribunal, but ultimately they're pretty much the same, particularly in this respect. There are also procedural rules of the court and the tribunal. When is an expert report admissible? In general, you come back to Section 79 of the Evidence Act. Now, okay, the rules of evidence strictly don't apply in NCAT, but they usually apply them in a commercial matter such as a home building matter. So in the tribunal they say it's a matter of fairness, and where do they go to for fairness? The guidelines are basically what's in the Evidence Act. So you've got to be an expert. What's an expert? That's someone who has specialised knowledge based on their training, their study or their experience in relation to the particular issue in the case. You can have, in a building case, if you're an expert in money laundering, that would be totally irrelevant. So it has to be the relevant expertise, and I think we've spoken previously here about particularly about quantity surveyors going out and doing defects reports and then a quantity surveyor doing a quantity surveying report that's based on a defect report that's been done by another quantity surveyor. Well, the first report shouldn't be admitted because the quantity surveyor doesn't have the expertise and the skill and the knowledge to talk about defects as opposed to the cost of doing certain work. And if you've got an ultimate author, if they are relying on someone else's work, that person has to have the same kind of qualifications. They have to be qualified to do what they have done as part of that expert report. And it's about a substantive contribution to the expert opinion. It's not, it won't be, for example, if you've just sent someone out to take some photographs, you do have to prove who took the photographs, when they were taken, that they're actually depicting what is actually there, but that person doesn't have to be an expert because it's not a substantive contribution to the report. But if they are making a substantive contribution, then they also have to have the relevant skills, knowledge, study or experience. So yes, you can rely on other experts, provided, as I say, it's the application of the specialised knowledge of the witness. And you can talk to somebody else. There can be a debate internally in your own office between the other person and you as the ultimate author. You can be influenced by what that other person says, their opinion, but you've got to take that and it then has to become your own independent opinion anyway. So you can't just adopt somebody else's opinion. You've got to show that it is actually yours, but as a result of discussion. You can't compromise. It's not a case of, oh, well, you say there are 72 peers, I say there's 35 peers, so let's settle on 50 and I'll put 50 peers in my report. You can't do that. It doesn't work that way. Okay. So this case that I'm briefly describing, it's not a building case, but it doesn't matter. The issue of expert evidence runs across all disciplines. So this guy got his son to help him write the report. Number one issue, wasn't clear from the report who did what, who contributed to what. The son didn't have the training, study or the experience to form the opinions. Where was he getting his opinions from? What his father had told him. He presumably worked with his father in the expert business and had heard his father ramble on over the years, as indeed my children have. But you can't just take somebody else's experience. If you're going to have a substantive input to a report, you have to have your own study, training and experience and skills. As I say, no way to identify who did what. So that was a compromised opinion and it was held to be inadmissible. Now, if somebody else is going to be contributing, you need to identify them. Why do you need to identify them? Well, if you're not identifying them, then we don't know what qualifications, training or experience has been employed, and so we don't know whether it's based on an admissible expert opinion or otherwise. And also, as a matter of fairness, the opposing counsel or solicitor has to be able to test the evidence of the witness, and they can't do that if they don't know who that was or what parts of the report have been contributed by that witness. And that applies whether or not you're having sequential expert evidence or whether you're being hot-tubbed, whether it's a joint expert witness situation where they're being cross-examined in the court or the tribunal. So very important issue of fairness there that comes into why authors need to be identified. So what do you need to tell not just your opponent but also the tribunal or the court? Who they are, obviously. If you don't know who they are, then you don't know what specialised knowledge they have. So how do they qualify as an expert? You've got to identify the parts of the report for which your co-author is responsible, and part and parcel of doing that is identifying what the roles of the authors are. and how was the report ultimately finalised. So that goes back to, well, you know, did you sit in the room and have a discussion, and one said black, the other said white, and you tossed a coin as to what was going to go in the report, or did you sit down, have the discussion, then the ultimate author go away, think about it for themselves, and then decide based on their own views as to which parts of the other person's opinion they would put into the report or not. So we do see these reports fairly regularly where, for example, it might be an engineer's report. I've got experience with an engineer's report where a particular engineer that we knew, we asked him to do a report. He's based in Sydney, the property was on the Central Coast. He sent his partner up there, who is also a qualified engineer, to do the inspection, take photographs, come back with a comprehensive report. They then sat down, went through it. The lead author, if you like, then wrote the report. He did, subsequently to the report, go up and inspect the site for himself, which only confirmed his original opinion and what his partner had reported on. In the engineer's report, it was fully disclosed as to who'd done what, and that was accepted by the tribunal without any difficulty because it had followed the rules. So you can do it, but you have to be careful about it, and you have to make sure that it's clear and transparent as to who's done what and who's decided what. Questions?
David, just in regard to the report that's been prepared by the owner already, so
Yes.
in regard to the inspection, so to site defect identifications, and then we got provided by some reports done by the owner, say plumbing report or say engineer report, as you mentioned. Is the expert duty of care to just investigate the source of this report, and is the person who provided is skilled enough or just qualified to just put this report? That's the first part of the question. The second one is, if I gonna rely on this kind of a report in my report, do I need to do the investigation myself, or what's the situation here? Because this is happening all the time, most of the time.
Okay. Well, the two parts of your question are related. So to answer your first part, yes, if you are going to rely on someone else's report, you need to satisfy yourself that that person was properly qualified, that what they're reporting on is accurate, and that it is something on which you can safely base your opinion in that respect. Now, that then flows over into the next part of your question. If you are unsure about it, and really as part of satisfying yourself that it's been done by an expert in that area and that it is reliable, you may well need then to go back and do it for yourself anyway. At least there needs to be some investigation of it. And in those circumstances, probably, if there's a lawyer involved, the lawyer should probably be making sure that the person, the plumber or whoever it is, who's done the initial report on which, or partial report on which you're relying, is going to be available for cross-examination if the other side wants them to be able to be cross-examined. And of course, that report needs to be an appendix to your own report.
Yep.
So that, again, disclosure, transparency, fairness. Yeah. Other questions? No? Okay. All right. I'll leave you to it. Thanks, John.
Thank you, David.
You're welcome.
Can I just...
Sure, you can take that.
Thank you.